We all belong to the same community, and a guru like this is very, very rarely available for us to give us all his knowledge transfer to every of our students, even a small or a big advocate, whoever it is. He's been groomed under him from last 50 years. He is the only one inspiration for all the people who are sitting on a better as a senior advocates. Throughout the class, I request you to open today.
Only for today.
Only for today. I request everybody throughout the class, switch on your cameras today. As a request from my end. Interaction ఉన్నప్పుడు మీ Now I'm muting everybody as of now. The class will go ahead and next 1 minute. Madam, unmute. None unmute చేయండి. Please go ahead.
Yes. Good evening to all of you. We were just discussing the law of drafting and pleading. Conveyancing I've already finished. As far as drafting and pleading are concerned, they both go simultaneously and they are almost synonymous except for the roots. I told you that when we were yesterday, I just gave an introduction. Today, we'll go into what is meant by drafting. Drafting is an art as well as a science. It is mastered by experience and mastered by long standing in the profession and trying to follow your seniors when they dictate a particular draft to you, how it has to be drafted. Here, in this regard, I've written a book on civil procedure code. I've given model plaints as well as model appeals also. I think the book's name is Key to Civil Procedure Code. It will be useful to many advocates because the model plaint and the model plaints in most of the matters I've given and how the appeal also is filed is also mentioned. Here, drafting means the word drafting comes from the word draft. Draft means write or how you proceed to draft a plaint. But before we go to drafting, we have to go to pleadings first and then come to drafting. Here, we are dealing with, as far as pleadings are concerned, we are dealing with the Civil Procedure Code, the various types of suits which are provided under the civil law. To name few of them, one is called a money suit, another is called a mortgage suit, another is called a suit for specific performance, another is called a suit for injunction, then another is called a suit for easement, and then next one is what is called suits for possession, suits for eviction, then suits for damages, suits under the Partnership Act, then suits as a pauper, then what is called interpreter suits, so on and so forth. They are all called civil suits. Here, pleading is first and foremost is, I've already discussed when I was discussing Civil Procedure Code, more particularly Order 6. Order 6 pleadings. What is the meaning of the word pleadings? Pleadings doesn't mean only the plaint. Pleadings means and includes plaint as well as written statement. Then second thing you must know is who files a plaint and who files a written statement. As far as the plaint is concerned, it is filed by a person called the plaintiff. That is Vadi and Prativadi as they call it in Telugu. And as far as the written statement is concerned, answer to the averments made in the plaint, the defendant enters defense and files the written statement. So plaint is filed by the plaintiff and written statement is filed by the defendant or defendants as you may call it. So the first and fundamental rule as far as pleadings are concerned is laid down in Order 6. It says, Order 6 Rule 1 says, all plaints which are filed into the court has to be filed in duplicate, duly signed, duly verified, and also properly mentioned as per the rules. First and foremost, the Order 6 Rule 2 says, rules of pleading, it says, plead and then prove. Please remember, when a child is hungry, it tries to alert the mother, look, mother, I'm hungry, please feed me. In the same way, when you knock at the doors of a civil court, you will have to make your grievances clearly and then tell the court, these are my grievances, please redress my grievances. Then how a plaint is drafted. Please remember, each man has got different styles of writing a plaint. Here, before we go to pleadings, I told you yesterday also, there are two systems of drafting. One is what is called the Anglo-Saxon method, that is what is followed by the Commonwealth, and another is called the American system of drafting, that is followed in United States and other European countries. Here, the question is, as far as Anglo-Saxon method means, where from the first word till the last word, blah, 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 it will be only one paragraph. In Telugu, they say, Antam Kadidi Arambam. You do not know where it has started, where it has ended. You are in a bundle of confusion. So it is preferable not to follow the Anglo-Saxon method, but it is better you follow the American system of drafting. Why? Because American system, they say, you go for short paragraphs, it gives more clarity, and the judge also is able to understand it properly, and you as an advocate appearing for the party, you can also explain to the court, this is my case, these are my grievances, please address my grievances. That is how American system is more preferable. Here, when you draft a plaint, you have to know what are the ingredients of a plaint, because I'm talking a plaint from the point of persons who are working on the trial side. We are in the subordinate courts as well as in the high court. But high court, you don't call it pleadings, you call it as what is called petition and affidavit in the high court. You don't file plaint there in the high court. The plaint is filed only in a civil court, that is in a subordinate court, or what is called the subordinate judiciary, not in the high court. Then what are the contents of the pleading, sir? As far as plaint is concerned, first and foremost is plaints are normally filed under the provisions of Order 26, Rule 1 and 2. Order 26 read with order Section 26 read with Order 7, Rule 1 and 2 CPC. Then you say whichever court it may be, in the court of so and so, Vijayawada or Hyderabad or whatever it is. Then all suits on the original side are numbered as OS. OS means suit on the original side is called OS. OS number. You leave it blank and then you say of whichever year, that's 2024. Then you give the names of the plaintiffs, their father's name, their address, their occupation, and so on. So you mention them as plaintiffs. Plaintiffs in Telugu is commonly called as Vadi or Vadulu. Then the opposite side against whom you file a case is called the Prativadi or Prativadulu, and they are called the defendants 1, 2, 3, and 4. Then you give the proper description correctly. This is as far as shortly called the cause title, CAUSE dash TITLE. Cause title means description of the parties. Then after that, you say again, if you want to repeat, you can repeat it. Plaint under Section 26, read with Order 7, Rule 1 and 2 CPC. Then suppose you are filing a suit for injunction or perpetual injunction, as you may call it. You say suit for perpetual injunction under Section 38, the Specific Relief Act 1963. Then the first one is the plaintiff above named begs to state as follows. Please remember, one of the present admin, Mr. Kalyan, was remarking, sir, why do you want to beg? The question is, we must go to the court with humility. We shall not express our pride and all, so that the court will not be offended. Then you say, court should not be offended, rather. First, name, address, and description of the plaintiff or plaintiffs as the case may be. Second paragraph should be name, address, and description of the defendants. There you write it very, very short. The address for service of all summons and notices on the defendant is the same as given above. Then after that, suppose you are the advocate appearing for the party, you'll have to say the address for service of all processes and notices on the plaintiffs is that of their counsel, Mr. So-and-so. Nowadays, you have to give the email number also and also the cell number also, your address. Then next one is address for service on the defendant, same. Then we come to the other paragraph called brief facts of the case. First, you mention it and go by subheadings A, B, C, D, E, and F. And please remember, suppose you've got 15 documents, let us say for argument's sake, you concentrate each paragraph for each document. So that suppose 15 documents are there, give it in the form of 15 paragraphs. Even because I think the gentleman who's sitting here must be sufficiently a senior. The question is, suppose your juniors are attending the court and you are not in a position to conduct the case, your junior looking into the plaint can definitely know, sir, these are the documents, these are the facts which have to cover. Then 1, 2, 3, 4, 5, 6, like that. If there are 15 documents, please mention it as 15 paragraphs. You don't lose anything by making sub paragraphs. Then the next one is, you say the next column should be the steps which you have taken to protest to the defendant and what is the response from him. Then after that, most important paragraph is cause of action. Cause of action means the bundle of facts and documents put together which gives rise to an action in a court of law is what is called cause of action. Cause of action means bundle of facts, bundle of documents put together, clubbed together, which gives rise to an action in a court of law is what is called cause of action. Why I'm trying to repeat this again and again is in most of the JCG examination, you are asked to define cause of action. Please remember the prelims are over as far as Telangana JCJ recruitment is concerned. Now we come to the essay part of it. So cause of action means bundle of facts and documents put together which gives rise to an action in a court of law is what is called cause of action. Then suppose you take an ordinary money suit. The date when the promissory note is executed, suppose 5/3/2000. The cause of action for the suit arose on 5/3/2000 when the plaintiff, when the defendant borrowed a sum of rupees so and so from the plaintiff and executed a promissory note and receipt dated so and so in favor of the plaintiff. And the cause of action also accrued on a subsequent date, that is, when he has acknowledged that he is liable to pay and endorsed on the reverse of it by paying rupees 500 or 1000 and says the rest of it I will pay in installments and he signs it. That means it also arose on that day when the defendant acknowledged his liability and acknowledged the debt due and payable by him and signed on it. So every endorsement that is made on a promissory note on the reverse of it gives you the cause of action. Right? Then, sir, I deal. This is as far as my. Then after that, you say how the court has got jurisdiction. How the I'll also discuss jurisdiction again, sir, because some of you were not there, joined later. Here, this honorable court has jurisdiction to try this suit as the suit document was executed at Hyderabad, and the parties reside and work for gain at Hyderabad within the jurisdiction of this court. Please remember, earlier we had what is called taluka sulli. That is before NTR came to power in 1984. In 1984, with the base population of a taluk was 2 lakhs. But for revenue administration, they found it difficult with such a big population to administer the mandals. So for revenue collections, they divided a taluka into 4 mandals. Every mandal comprises of a population of 50,000, 50,000, 50,000, 50,000, 50,000. That means a taluka was divided into 4 mandals. And in jurisdiction is, this honorable court has jurisdiction to try this suit as the suit schedule, as the promissory note was executed at let us say Anandabad, Malkajgiri within the jurisdiction of this court. Then after that, we value the suit for the purposes of court fee. You say the suit is valued for the purposes of court fee and jurisdiction at rupees so and so, and a court fee of rupees dash is paid under section. If it's a money suit, it is section 20, read with schedule 1, TGCS SVC Act. That means now they have had, except we have nothing. It is old wine in new bottle. The same AP Court Fees Act has been followed here in Telangana. Only thing is it has been adapted by Telangana government, but the prefix is TG instead of AP. Then after that, under the relevant provision, you pay the court fee. Then you can ask me, sir, for a money suit, what is the provision under which you pay the court fee? It is section 20, read with section 20, read with article 1B and C, schedule 1 of the Court Fees Act. Then after that, you come to a declaration. You say the plaintiff hereby declares that he has not filed any suit in respect of the same cause of action in any court, nor any suit is pending in respect of the same cause of action. Then one more paragraph after that, the suit is within time and within the period of limitation as the suit promissory note was executed on so-and-so date, and subsequently it was acknowledged by the defendant on so-and-so date when he admitted his liability. Then the last paragraph would be that to say That will say the plaintiff further declares he has not filed any suit. After that, the prayer clause. The plaintiff therefore prays, plaintiff or plaintiffs as the case may be, therefore prays for a judgment and decree against the defendant and or defendants as the case may be, jointly and severally as follows. But the tendency amongst advocates has been to give a complex sentence. Whatever you have to claim, you mention it in 3 lines or 4 lines. No, it is safer for you to make it into sub-paragraphs and say, the plaintiff therefore prays for a judgment and decree against the defendants 1 to 4 so and so, jointly and severally as follows. 1. For recovery of rupees so and so to due by the defendant towards hand loan with interest at 24% per annum from date of suit till date of realization. That is one. Second one is the defendant for a sum of rupees so and so claim towards damages. Then third one is cost of the suit. Then the party signs, and then he also verifies that the averments that are made before the cause of action paragraph are true and correct. And after the cause of from the cause of action paragraph, he says, "They are true to the best of my information and belief, which I believe to be true. After the contents were read over and explained to me in Telugu, which I understand, and then hence verified at Malkajgiri or Hyderabad or Secunderabad, whatever it may be, then the plaintiff or the plaintiff sign, and the counsel also signs. Then after that, the list of documents which you are relying as far as the suit is concerned, 1, 2, 3, 4, 5, 6, and all, you mention it, and then the party also signs. If it is relating to immobile property, the schedule of the property also has to be given with the area as well as the boundaries, and the schedule also has to be verified by the party. And then, of course, all of you know as advocates, the docket also has to be prepared on one side and then filed into the court. And please remember, all the plates which you file into the court on the original side has to be filed in duplicate. You can ask me one question, sir, why it is in duplicate? Please remember why it is in duplicate, because the court, whenever it hears arguments, it also makes its markings on the duplicate plate. And then one more copy you are supposed to file for the computer for the purpose of scanning. Earlier, what they used to do is the entire verbatim plate used to be copied in a book called the suit register. Now, please remember, clean and green. We are in the era of laziness. The clean and green is they just take your plate and then paste it to that particular book, so that anyone who wants a copy, they take out a Xerox certified copy and then give it to you, and that's as good as original. Then, when you file a suit in respect of immovable property, that is as far as money suit. I think you have followed what is a money suit. We'll finish plaints and then come to the written statements. Then the second type of suit which you file is a suit for specific performance. Suit for specific performance as laid down in section 10 or 12 of the Specific Relief Act. Here, what do you exactly mean by Specific Relief Act? Specific Relief Act means that where an agreement is made, there is an offer, there is an acceptance, there is a capacity, there is consideration, there is free consent, and there is legality of object as laid down in section 6 of the Contracts Act. And when the other side violates the terms of the contract, you are not without any remedy. You can enforce that contract in a court of law. And that type of suit is what is called a suit for specific performance. Normally, a suit for specific performance is filed under section 10 or 12 of the Specific Relief Act. The same contents you mentioned, but here one thing is this: when you say you spell out one taken place, that on so and so date, the defendant promised to sell his property bearing number so and so, situated at so and so, for a total sale consideration of rupees so and so, and executed an agreement of sale dated so and so in favor of the plaintiff. And at the time of agreement of sale, the plaintiff had paid a sum of rupees so and so towards advance and earnest money, and the rest of the balance of the sale consideration was agreed to be paid at the time of execution and registration of the sale deed. The original agreement is filed herewith and marked as document number 1. Next para. So subsequent to the agreement of sale, the defendant executed a supplementary agreement whereby he modified certain terms and conditions, and the original contract was novated, and a new contract had come into the picture, and there was an enhancement of the sale consideration. The time for payment also was extended. Then the supplemental agreement in original is filed and marked as document number 2. Then after that you say, subsequently, since the defendant was evading and avoiding execution and registration of the sale deed, the plaintiff, through his legal notice dated so and so, called upon the defendant to execute and register the sale deed. The defendant received the notice but did not send any reply nor execute the sale deed, and hence the plaintiff is constrained to file the suit for specific performance. Then you say the office copy of the legal notice with the post acknowledgement is filed and marked as document number 3 and 4. Then after that, next para is, cause of action for the suit arose on so-and-so date when the defendant promised to sell the property belonging to him and executed an agreement of sale, and subsequently the terms were modified and a supplemental agreement was executed on so-and-so date, and from that day I've got a right of proceeding against the defendant. Then after that, you come to the limitation paragraph. The suit is within time and within the period of limitation as the original agreement of sale was substituted or novated by a supplemental agreement dated so and so, and the obligations under the new contract alone has to be performed, and also because the uh, uh, because the question is, since the original agreement was novated and the suit is within time, and the legal notice was given calling upon the defendant to execute and register the sale deed, and since the defendant did not execute the sale deed in spite of several demands and requests and in spite of the legal notice, the suit is within time. Next paragraph. The suit is valued for the purposes of court fee and jurisdiction as follows. A. On the relief of specific performance at whatever consideration is mentioned in the agreement of sale, and the entire stamp duty is payable on that, and you value it under section 39 of the Court Fees Act. The suit is valued on the relief of specific performance at 50 lakhs or whatever it is, and a court fee of rupees dash is paid under section 39 of the Court Fees Act. Second one is on the relief of liquidated damages as mentioned in the agreement of sale at 5 lakhs, and a court fee of rupees so and so is paid under section 20 of the TSS CV Act. Next one is for the relief of notice charges is valued at 5,000 or 10,000, and a court fee of rupees so and so is paid under section so and so. There is section 20, and the total value of the suit equal to so and so, and the total court fee paid is so and so. And also you say the court fee of rupees so and so is paid wide bank challan number so and so, dated so and so, on State Bank of India, whichever branch it may be, because all the courts have the account with State Bank of India only, but different branches. Then you file the what is called, I told you after the Telgi scam, no court fees are being printed now. You will have to deposit by way of a pay slip in the account of the court, and then the bank gives you the counterfoil. The counterfoil has to be filed along with the plaint, and it's advisable that you take a Xerox copy of the also, and don't give it to your client, please. If you paste it on the plaint. Why? Because I'm telling you, I'm not preaching dishonesty, please. The clients, please remember, when we started practice, the clients used to pay the fees on one side, expenses on one side. Now, if you ask the client, what he will say is, expenses will pay. Fees kidhar jata sab bank mein hai samjho. The question, that's why you see every advocate leaves the court fee paragraph blank. What court fee is being paid, only he knows, and he doesn't even inform the client how much court. I'm not preaching dishonesty, please. This is a practical outcome, because sometimes what happens, but one thing, when you are appearing for an institution like a bank and all, bank knows everything. You can't fool the bank. The question is, you will have better when you appear for a private party, keep the court fee, what you court fee you pay, keep it blank, and never give the counterfoil to your client, or never ask your client to pay the court fee, because he will calculate everything and take a Xerox copy and sab itna hi na sab court fee, aap itna bole, you have knocked off that money, straight away will abuse you also. Be very, very careful. But sometimes, they don't wag their tail when they come to a senior advocate. The question is, expenses itna hota, by fees itna hota. And normally when we appear for the bank, what they do is, they pay 25% at the time of filing, 25% at the time when the issues are framed, and the other 50% is paid after you take a decree and give them the copy of the decree. The entire fees is paid, not otherwise. And even the process, what you pay for notice to the other side, they pay you only 2 sets or 3 sets. The difficulty comes if the party is not served. You go on paying from your pocket, with the result that even that one-fourth fees which is paid to gets exhausted. That is a trend of banks also. Anyhow, the question is, so after that, what you do is court fee you pay accordingly. Then after that, you say the suit is within time and within the period of limitation. And then after that, you come to what is called no suit is filed or no suit is pending. Then the last one will be prayer. Prayer has to be very carefully worded, sir. The plaintiff therefore prays for a judgment and decree against the there's only one difference always, against the defendants jointly and severally as follows: for specific performance of the agreement of sale dated so and so, executed by the defendants in favor of the plaintiff. B, for liquidated damages of rupees 5 lakhs for the violation of the terms of the agreement. C, for cost of the suit. 4 is to say whatever such other order or orders as this honorable court deems fit and proper. Then the plaintiff signs beneath it, and then the counsel also signs on the other side. Then the party also verifies that the facts mentioned above is true and correct, and also says that the facts mentioned in the legal paragraphs are true to the best of his information and belief after the contents were read over and explained to him in Telugu, and then verifies at the place where the plaint is to be filed, and then he signs. Then after that, whatever documents you rely upon, you say list of documents filed along with the plaint. Then 1, 2, 3, 4, 5, 6, and all, then the party signs. Then after that, if it is relating to immobile property, the schedule has to be clearly given. All that piece and parcel of agricultural land in survey number so-and-so, advisory so-and-so, situated at so-and-so, bounded on the east by so-and-so, west by so-and-so, north by so-and-so, and south by so-and-so, and the schedule which is given also has to be verified by the party. And then after that, docket and all these things are there. Then whenever you file all this, you are also supposed to file, because the CPC has been amended. I think most of you know that CPC has been amended 3 times after 1908. One was in 1976, that is Act 46 of 1976. Again, it was in 1999, the CPC was sought to be amended, but it was a stillborn child because some of the draconian provisions were there which affected the interests of the advocates, and all the advocates throughout the country went on strike, and 99 was not implemented also. But the present amended CPC that is applied is the Act 22 of 2002 CPC. It came into effect from 1/7/2002. Here, as far as the amended CPC is concerned, they introduced a provision called Order 6, Rule 15, bracket 4, CPC. Order 6, Rule 15, bracket 4. And a verification affidavit has to be filed by the party, vouchsafing also and stating that the facts mentioned in the plaint are true and correct, and they are made by him with full restraint and responsibility, and the plaint has been drafted as per his instructions, and then he signs as a deponent. Please remember, again I told you that if he's a Hindu, he writes the word deponent, and if he's a Hindu, he takes oath. But as far as a Muslim is concerned, Muslim, it is against the religion to take oath. That's the reason they say affirm and state as follows, and he is not called the deponent, he is called the affirmant. Affirmed and signed on this so-and-so, and another advocate who is not the advocate for the party has to attest that particular affidavit. And please bear one thing in mind is the social responsibility, the professional responsibility of an advocate who attests a particular affidavit without knowing the party. It is better you take the identification from the advocate who submits the paper for attestation. Why? Because tomorrow if the party says my signature is a forgery, and the advocate concerned who has attested it and my advocate have both colluded with each other and brought into existence a document which is never signed by me. That is the reason, sir, I just take an analogy to the criminal law, sir. What happens is, in criminal law, there's a provision called Article 21 and 22 of the Constitution, rights of personal liberty. Whenever hanging sentence is given, you can hang a person only once. You cannot hang a person twice. That's why what they do is, in one case, what happened was the noose was put on the neck of the person was to be hanged. But what happened, unfortunately, was he did not hold the noose. It never caught his neck, but it came away. Then the question arose whether the noose can be put again, or the rope can be put again on the accused. What the court said was, you can hang a person only once. You cannot hang him twice. So that is the reason the death sentence also, which is passed, the court say hang until he is dead. Hang until he is dead. Then the question is, uh, it is subject, even when a hanging sentence is given, death sentence is given, it's subject to confirmation by the High Court. But the present trend seems to be that death sentences are very rarely given. Why? Because it is against humanity. They say it cannot be tooth for tooth and nail for nail. You have killed that man, so we will kill you. It is nothing but state killing. It is not permitted. That's the reason why they give life imprisonment. But why I'm trying to draw an analogy to that is verification affidavit. Please remember, don't trust your client always. Your client. Suppose let us some inconvenient question comes in cross-examination. Are Babu Rasna, sir, in Rayalesa, Peter sir, my advocate only has written it. Please remember what interest I have got to write about his case. The question is, unless the client gives me instructions, I don't write it. So the question is to protect an advocate against misconduct, or protect an advocate against being disqualified, or protect an advocate against the villainous designs of your own client who wants to disown you. This verification affidavit has been at the Kavacham Laganma. It's like a shield for you to protect you against any future action by your client against you. And you understand, please. Then one more thing is also included. Order 6, Rule 14, which was not implemented till now. Courts were sleeping over it. What they do is they ask you to file an affidavit. Say, sir, affidavit in the sense, they'll say that I so and so, so and so. Then you say the name, address, and description of the plaintiff, name, address, and description of the defendants, and you say, I hereby vouchsafe to the fact that the addresses mentioned above are true and correct, and then the deponent signs it in proof of the addresses being correct. Then I think it is not followed in Hyderabad, but in Andhra area I've seen. You have also to file one more affidavit called under section 26(2). When you file a plaint, same verification affidavit is again followed, and the same facts are mentioned. Please remember, whether you call it Hyderabad, whether you call it Telangana, or whether you call it Andhra, I mean, that's the reason why we people are losing our hair also being in the profession. Because the papers which you file in the court, and the number of papers you file into the court is much more than what is the fees paid by your client. So, but in Mumbai, I've seen, sir. Mumbai, the question is, the procedure is shorter. Procedure is not lengthy as what we find, because we follow the Madras system, because we are part and parcel of the composite Madras state earlier before the Vishal Andhra. But these are the formalities which you have to satisfy. Sir, then why I'm trying to tell you all these things is, especially in suit for specific performance, you must remember one thing. When you come to a question of limitation, normally what is the time span for enforcing an agreement, sir? Can you tell me? Under Article 54 of the Limitation Act, it is 3 years. But most of us forget that proviso. In the proviso, it is said, if the time limit is not fixed, it is 3 years from the date of refusal, or where the plaintiff the defendant has disabled himself from performing the contract. That is the reason why we give a notice. Why we give a notice calling upon the defendant to execute and register the sale deed and say that I am ready and willing to perform my obligations. You please come and execute and register the sale deed. So you get a fresh period of 3 years from the date when you give the legal notice. That means you get an extended period, right? So that is the reason when you want to come under the proviso to Article 54, that also you have to plead. To say you have given a legal notice expressing your readiness and willingness to perform your part of the contract. The defendant received the notice but did not send any reply, nor executed and registered the sale deed, and hence the suit is within time and within the period of limitation. That is one way. The second one is, suppose the original contract is novated. What do you mean by novated, sir? It is replaced or substituted by a new contract. The obligations under Section 61 of the Contracts Act says the obligations under the new contract alone has to be performed. The old contract is to an end. Or let us say the old contract is modified, old contract is varied, Our old contract, there are some changes in that. You mentioned a supplemental agreement was made on so and so date. So the obligations under the supplemental agreement alone has to be performed and not on the original. Then I'll give you one more example, sir. Under the Transfer of Property Act, there is one section called Section 55 bracket 2. As far as the limitation part of it is concerned, time is not the essence of the contract as far as immovable property is concerned. That is the reason, sir, in the sale deed and all, in the agreement, what we write is the vendor hereby agrees and undertakes to execute the sale deed as and when called upon by the vendee. These are all the words coined by our by clever advocates, sir, Mr. Nagachandram, so on and so forth, so that to keep your client's interests alive, that whenever I call upon you, you must execute the sale deed. Again, there, the 3 years period does not come. Why, sir? Because I'll call you at any time and ask you to execute the sale deed. Another thing is, in the agreement of sale itself, sometimes you find the land has to be surveyed, the help of the survey and settlements has to be taken, then you have to fix the boundaries, then you have to localize the land, then fix the cutty stones, so on and so forth, or obtain for permissions, obtain for exemptions, obtain clearances from the government or from any other authority. That period which is spent for the purpose of obtaining permissions or clearances or permits is excluded for the purpose of computing the 3 years period, sir. So this nothing but drafting is nothing but a jugglery. Your pleadings, how you draft it, is you'll have to go through all the documents and then plead it, then prepare the pleadings in such a way that it appeals to the court and you succeed for your client. Then when you file a suit for specific performance and when it's relating to immovable property, you will have to file a form called Form number 8. Form number 8, printed form is available. That is what is called valuation of the property. That is description of the property. That is serial number, survey number, then extent of land, then extent of land held by so-and-so, then rental value of the land, then next one is market value of the land, then what is called, the question is, under what provision you have paid the court fee, then your client also signs it and then you file it. So form number 8, you also file it along with the print. Then you also pay what is called bata or what is called process, talwana as you call it in Urdu. That means process is you have to send form number 61. As far as the civil rules of practice is concerned, printed forms are available for that. You fill it up and then along with that, when it's a civil suit, you fill up a form, small form called summons for settlement of issues under Order 5. That whenever because you are now supposed to send it by court as well as registered post, you have to submit 3 forms for each party. Then file it in the court. And then if you are asking for any interim relief, then the process also has to be paid for issuing notice under that interlocutory application. And also what forms you file along with an IA is what is called notice for show cause general. What you file, the IA number of so-and-so, in OS number of so-and-so, then the names of parties to whom it has to be addressed, so on and so forth. And then you file it in duplicate. And as many parties, you must file that number of show cause notices. Settlement of issues, suppose there are 5 parties, 5 into 5 means 3 into 5 will be 15 forms have to be submitted. Process form will be only 1. Then the civil rules of practice also says that you must supply the copies of the plains, extra copies of the plains to all the defendants as there are in the suit. And along with that, you are also supposed to send the copies of the material papers, that is, the copies of the documents which you rely as far as the suit is concerned. 1 copy has to be given to each defendant. These are the rules in the civil rules of practice, sir. Earlier they were giving a go by to it. Suppose, let us say, someone, let us say, suppose this madam is there. Say, madam, give me a copy of the plane. What she'll say is, go and take a certified copy, man. I'm not going to give you a copy. But now you are supposed to give a copy. Whatever documents you file, a copy of the document has to be supplied to the opposite side. Then you may ask me a question, sir, what is the provision under which this is provided? You have got civil rules of practice, rule 125. Civil rules of practice says every defendant is entitled to get a copy of the plaint, copy of the petition, copy of the material papers, and unless you give the copies, the case will not proceed. Suppose the party does not give you the copies, you can just file a memo before the court under 125 and ask the court to issue directions to the defendant to furnish, to the plaintiff to furnish documents. Even after the court gives directions, the party does not furnish documents, then under 127, the court can strike off your claim and reject the documents which you have filed. So these are the consequences as far as 125, 126, and 127 rules are concerned, as far as civil rules of practice is concerned. So these are the two types of suits which I have discussed, sir. One is a money suit, another is what is called a suit for specific performance. Then let us go to the third type of suit. I think most of you are practitioners. You know there's an enactment called the Transfer of Property Act of 1882 or 1872. There they say section 60, once a mortgage, always a mortgage. Especially in Andhra area and Chennai, there are two enactments. One is called the Moneylenders Act, and in Chennai it is called the Pawnbrokers Act. No man can carry on money lending business without having a proper money lending license, or he has given the authority to carry on money lending business. And any person carrying on money lending business without license, the amount is not recoverable. So here, to avoid the Money Lending Act or the Pawnbrokers Act, what people are now doing is they are entering into some hybrid documents also. Here, suppose the property is worth about 50 lakhs, they get an agreement of sale for 30 lakhs. Indirectly, what happens is that 30 consideration what you mentioned is according to the book value, but you avoid payment of extra court fee. But if you see, the question is here. What was Unfortunately, right from morning I've been working. Here, as far as the suit is concerned, you value at the figure that is mentioned in the agreement. That will be the value for the purpose of court fee, etc., etc. The third type of suit which we'll discuss is what is called mortgage suits. Mortgage suits, please bear it in mind. Most of the advocates are committing a mistake by mentioning the same thing. Plaint filed under section 26, read with order 7, rule 1. Please remember section 26, order 7, rule 1 does not apply as far as mortgage suits are concerned. Mortgage suits is mentioned in an order called order 34 CPC. They are called mortgage suits. Mortgage in agency area, it is called Tanaka, and here it is called in Telangana, because ours is half Urdu and half Telugu, we call it as Girvi or Adamanam as they call it. I think in Tamil also they call it as Adamanam only. But in Andhra area they call it as Tanaka. Here, you must, before going to that, you must know what exactly is meant by mortgage. Mortgage means where interest in respect, section 58 defines what a mortgage is, where interest in respect of specific immovable property is created for the purpose of securing a loan which is paid, promised, part paid, or part promised. It is called a mortgage. And the person offering the property as security is called the mortgagor, and the person to whom the property is offered as security is called the mortgagee. And the consideration is the property, the security. The security is the essence of the mortgage, because every contract has to be supported by consideration. The property which you offer as security itself is sufficient. But one thing is part paid or part promised. Why do we say part paid, sir? Mostly, when you apply for a bank loan for working capital or credit facilities, they'll give you up to a particular limit, isn't it, sir? You apply for a loan of 1 crore. They don't grant you 1 crore immediately. First and foremost is, based on your collateral security, they grant you loan up to a limit of 50 lakhs. Not that 50 lakhs is going to be paid immediately. They release it in stages. First they give you 5 lakhs, next they give you 5 lakhs, next they give you 5 lakhs, like that. But maximum which they can give you is not beyond 50 lakhs. Suppose you want more, they want to extend your limits, then you will have to give other collateral security, other property, and then the bank. That's why you say part paid and part promised. Why do you say part paid and part promised? That means whatever documents are executed initially at the time of availing the loan, they are called primary documents, isn't it? They hold good till the end. No fresh documents are taken. Are you able to understand, please? The documents which you already execute in favor of the bank holds good till the last. That's the reason it says part paid or part promised. It is called a mortgage. Here, a mortgage suit is a very peculiar type of suit where the entire, like a money suit, you draft everything. But when you go to a bank for a credit facilities, it is always said a beggar cannot be a chooser. The bank will not give you time to read the document. And they'll also say, please sign on dotted lines. I still remember I conducted a case on behalf of the State Bank of India before Justice Ramsamy. Of course, he's no more. He was elevated to the Supreme Court also. What happened was the word that is used in that, I think all the bank documents, if you carefully see, they are all the documents not prepared by our Indian people. They are all prepared by the Imperial Bank. Imperial Bank was the predecessor to the State Bank of India. State Bank of India came into existence only in 1955. 1956, the subsidiary banks came into the picture. But before that, we had the Imperial Bank when the East India Company was there. So the same documentation which was done was copied and adapted by our Indian government. Here, there is one thing in law called continuing guarantee. Here, and they made a distinction by saying it's a marriage forever. That is, you cannot leave it in the midway. They say there is a particular clause there in the second page, if I'm correct, clause 4 or clause 5. They say the continuing guarantee is operative and not barred by limitation, even though the claim against the principal debtor may be barred, and the bank has got the right of recovery as against the guarantor till such time the entire amount is paid. And then స్వర్గమో నరకమో ఆ పెళ్ళంతోనే మనం కాపురం చేయాలి. That's what is that continuing guarantee. And Justice Ramsam, I think that was a reported judgment also. The batch, I think if I'm correct, 75 or 74. ALT, or I think at that time we had APLJ. It was reported, it was a judgment rendered by Justice Ramsamy. He says still it is something. He also made a humorous remark by saying it's a marriage forever, whether your wife is a sage or a devon, you will have to live with her throughout your life, whether you like it or not. That's what Justice Ramsamy openly said. So continuing guarantees, even though the claim may be barred against the debtor, when the guarantor executes the guarantee agreement, he binds himself till such time the entire debt is completely paid. So they said the guarantor cannot be discharged. That was the judgment rendered there. Please remember, bank documents are very, very clear, sir. Bank documents, if you clearly see, all these are colonial clauses which are added, sir. And no one looks into it, because a beggar, I told you, a beggar cannot be a chooser. Beggar will ask me to sign a dotted lines and then goes away. The real problem comes when he has to face the music in the court. So this clause was there. I think it was a batch of 34 revisions which were disposed of by Justice Ramsamy, holding it in favor of the bank, saying that the bank has got a right of recovery against the guarantor. The guarantor took a plea. Sir, I've given a guarantee only for 100 days, and the 100 days has already expired. Since it's already expired, my guarantee has come to an end. I am not liable. But what the court said was, till such time the entire debt is repaid, you are liable. That was the judgment rendered as far as continuing guarantee is concerned. Then let us go further, sir. As far as a mortgage suit is concerned, the only difference between a money suit and a mortgage suit is there must be a paragraph under the Order 34 to give the particulars of the mortgage. What are the particulars of the mortgage, sir? Name of the mortgager, name of the mortgagee, securities offered, description of the property, documents deposited, then boundaries of the property, amount sanctioned, interest charged, amount paid, and amount outstanding. So these are the clauses which you have to fill it up and mention it in a separate paragraph. You say particulars of the mortgage. A separate paragraph has to be given under Order 34 explaining the mortgage. Then the other difference comes when we come to the cause of action paragraph. Please remember, I think as this gentleman told me, that it is prompts or not is 3 years for enforcement, isn't it? But as far as the mortgage is concerned, it is 12 years from the date when the money becomes due. It is under Article 61 and 62 of the Limitation Act. So here you say the cause of action for the suit arose on 15/4/2000 when the defendant borrowed and received the hand loan or received the credit facilities, executed documents in favor of the bank, and also on so and so date when the defendant deposited the original documents of title pertaining to his property by way of collateral security and equitable mortgage, and also on so and so date when the defendant admitted and acknowledged his liability and executed documents, and therefore the suit is within time. That's how we mentioned, sir. So that is the difference between a money suit and a mortgage suit. Then after that, other paragraphs and all you have to come to. But in the prayer clause, we have to be very, very careful, sir. In the prayer clause, we say the plaintiff therefore prays for a judgment and decree against the defendants jointly and severally as follows. 1A. Please remember, in a mortgage, there are two reliefs which are granted. One is a personal relief, that is, you can proceed against the defendant personally for payment of the money, and B is in default of payment for a preliminary decree for enforcement of the charge on the immovable property that is offered as security by way of foreclosure or sale, so on and so forth. So, what do you mean by foreclosure? Foreclosure means before the mortgagor exercises his right of redemption, all his rights will have to be sealed, and he should not have any right to get back the property. And naturally, the property which is offered as security also has to be sold for recovery of money. So, it is a personal decree as well as a decree in default, that is a preliminary decree for enforcement of the charge by proceeding against the property that has been offered as security. Then again passed so on and so forth. But please bear one cardinal rule is there cannot be a decree for installments as far as a mortgage suit is concerned. Order 19, or Order 20 does not apply as far as mortgage suits are concerned. What can be granted is time for redemption. Equity of redemption is granted. You are given 3 months' time or 6 months' time to pay the principal, interest, and cost of the litigation, and on payment, all the securities which are had and received by the creditor from you will be ordered to be returned. That is the consequence. So the question is, please remember, I think Srimati Anuradha may be able to tell me. The question is, no advocate allows a case to end with the lower court. If we allow it to end with the lower court, our profession will be at the end. So we try to give some glimmer of hope to the client. Sir, after all, this is only a sub-court. You've got the district court, you've got the high court, you've got the Qutub Minar, that is the Supreme Court, where we can get proper relief. Ultimately, you have to pay. Again, come back to the lower court. The question is, that's how a mortgage suit is not disposed of within 10 years, minimum 10 years, if you ask me. It takes 10 to 12 years to get a mortgage suit disposed of. By the time the debtor also dies, his LRs will come on record. LRs of LRs also will come on record. So these things go on. Well, we can continue the rest of it tomorrow. I'll also give you the suit for redemption and what are the documents you filed in a mortgage suit and how it is filed, so on and so forth. Thank you very much, sir. Time for interaction starts.
Madam, the interaction section, unmute. Yes.
Just a minute.
Yes, sir.
Yes, just a minute, sir. Any questions, please?
Unmute.
Sir, request to everyone, please check your WhatsApp. I have sent some kind of messages in Dharma Legal 2 and 1 also.
Sir, Kashinathan, sir.
Kashinathan, please go ahead with your question.
Sir, actually, sir, if you don't mind, one copy of the drafting, can you just put it on the site, sir?
Which one, sir?
One sample copy, sir.
Sir, I tell you, if you just see a sample copy, if you are, where are you practicing, sir?
Sir, now in Delhi, sir.
Delhi, sir. In fact, I try to put it on the chat box. I will ask a colleague to do it. I've mentioned it in my book itself, sir. What is the model plaint?
Model plaints I will give you, sir. No problem. I have everything. Myself and sir, both of us written it. We will definitely provide that book, and I will even ask. We will ask the publisher to get some books to us. So if it is, I will make sure it is reaches to you in a proper way.
Okay, sir. I have joined with on AOR Delhi, sir. Supreme Court, sir.
Oh,
I have joined with Supreme Court.
Congratulations, congratulations,
with AOR, sir. With AOR as junior, sir.
Congratulations. And as a request, I made it. Please make a video of sir as
Yes, sir.
whatever students you are, you can please mention your bar and everything, and please send it to my WhatsApp, which I mentioned.
Okay, sir. Okay.
Thank you. Please go
Sir,
ahead, Vasant.
Happy
Vasant
Guru
Rao.
Purnima Day, sir.
Yes,
Happy
Mr.
Guru Purnima Day to you, sir.
Thank you very much, sir.
So you imparted your knowledge, which is very useful for all of us.
Thank you, sir. Thank you. I'm obliged.
Very much grateful to you, sir.
Thank you, sir.
Sir Vasant Rao, please go ahead with your question, sir.
Sir, good evening, sir.
One second, sir. 1 second, Mohammed, sir. 1 second. I'm just coming back to you.
Sir, good evening, sir.
Thank you for your wonderful lecture. Sir, actually, I wanted to intimate that I am not added in any legal.
I'm not able to hear you.
Sir, please be loud, sir. I'm not able to hear you, sir.
Please be
Vasant Rao garu, you are not
Sir,
audible.
sir, please listen, sir.
Now you are not.
Sir,
I am
good
able to
evening,
hear
sir.
you right now.
Sir, good evening, sir.
Good evening.
Sir, in a suit for specific performance, while suit is pending, the scheduled property was sold to some other person, sir. What we have to make them party also?
You have to make them party and also amend your plaint. You say the defendant and all persons subsequent purchasers should jointly and severally execute the sale deed in favor of the plaintiff. You must implead them also.
Complete them also.
Yes.
Then the list pendants cannot come on the way,
They
sir.
come on list pendants, but safer to implead them, sir. Because tomorrow you will be giving them an opportunity of filing a suit for declaration that they were not made parties and the decree is not binding on them.
Okay, sir.
మా అడ్వైస్ ఇచ్చేదంతా మన అడ్వకేట్సే కాదండి బాబు.
Mohammed, sir, please go ahead with your question, sir.
Sir, happy Guru Purnima, sir.
Thank you, sir.
Thank you for your wonderful lecture.
అలా వసే సార్. Thank you.
Actually, I wanted to tell you that I am not added in any Dharma legal group.
That's
So
okay, sir.
kindly add my number.
I think you have my number.
I was added in the Vakil Saab group.
All right,
sir.
sir. You find. Please take my number and put a WhatsApp to me. I will definitely give you a link.
Sure, sir. Please tell me your number, sir.
891
Chat box లో పెట్టు.
Okay.
964
Okay.
0
Okay.
157. I'm Advocate Kalyan here.
Yeah. Thank you so much, sir.
You
Sir,
can
today
call. You can
this
give
was
me a
my
call
first
anytime for any kind of
Very
doubts. We
wonderful,
will clear it up.
Sir, once more your number.
Sorry, sir. I didn't get you, sir.
If for any kind of doubts in civil and criminal, we are here ready to help you out.
Sir, your number, please, sir.
891 964 0 157. I'm Advocate Kalyan here. Thank you. Please go ahead with any more questions. Please go ahead. We are here to waiting for your questions more of.
Yes, Mrs. Anuradha. You were not there yesterday.
Please unmute yourself, madam. You're not. I'm not able to hear you. Not audible. Not audible. Now audible.
Sir, at the outset, I would like to thank you and offer my pranams on this auspicious occasion of Guru Purnima, and thanks to Kalyan Garu and Varalakshmi Garu
Thank you.
for
I'm obliged.
arranging everything.
Nothing, madam. It is a small gift towards my Guruji. What I am doing is only because of him. What I am here right now is all because of my Guru, my Tata, my Santhanam Tata.
And you have included all of us into.
We are all his kids, madam.
Yes,
Thank
we are
you.
all into.
Thank you.
Thank you so much.
Right.
Thank you so much.
All right. Any more questions? Please go ahead. Questions for today? Any type of questions, you can go ahead. All right. And there's a request from my end. I have given a message in the Dharma Legal group. Please post your a little small video kind of thing, a 1-minute video regarding your things. Please check. It's not a compulsory. It's your choice.
Good evening, sir.
Good evening.
Yes, Mr. Vijay.
This is Vijay, sir. I am from Jairabad, Sangareddy district, sir.
Yes.
Please.
Sir, could you explain how become the ancestral property become a self-acquired property?
Ancestral property can never become a self-acquired property, sir. Ancestral property always remains ancestral property. Only thing is the test is it should come from ancestors. That is from generation to generation. Or what they call it in Hindi is PDC. And as far as Muslims are concerned, it is supposed to there are only two types of properties. One is called a heritable property, that is matruka property, and one is called self-acquired property. And the shares, as far as Muslims are concerned, is very much settled. If there are more than one widow, suppose 4 widows are there, if they don't have children, 1/4 is shared by them equally, and the other 3/4 goes by way of inheritance. Males get 2 and females get 1. And there are 3 types of sharers there. One is sharer, another is residuaries, and another is distant kindred. But in Hindu law, the question is we have got class 1, class 2, class 3. But women also get equal shares under section 29A and section 6, especially after the passing of the Hindu Succession Amendment Act of 2005. And I was the first person to write an article to say the Pandora's box of dowry deaths have been opened by amending the act. Why? Because the sons-in-law were all dormant till that time. I woken up suddenly like a Rip Van Winkle and said, "Sir, where is my share? Where is my wife's share?" And the wife says, "Ma పెళ్ళంతా బాగా చేశారండి మా తండ్రి గారు ఎందుకు అడుగుతున్నారు అని నీకు ఇచ్చారమ్మా నాకేమి ఇచ్చారు." So the question is the avarice or the greed of a person remains always. And even if the party agrees for it, we as advocates say, "Dawa daldo bhai, kuch to bhi aata." The other side will come for a compromise. Would you follow, please? Now, please remember, women are supposed to be more powerful than men now. Because gender justice. Everywhere they want reservation. Of course, I'm not against reservations, please. 33.5% reservation in the judiciary, 33.5% in the jobs, and they want 33.5% in the parliament and legislatures also. But so long as we have the reservation policy, I don't think that 33.5% will be implemented in parliament and legislature, because so long as we have parties like Akhilesh Yadav and Lalu Prasad Yadav, they say they want reservation within reservation. Women reservation means SC woman, SC1, SC2, SC3. Perhaps you are coming up to SCZ. Perhaps the alphabets will have to be rewritten again. You'll have to have like what you have for a vehicle, ZA, ZB, ZC, like that. So the question is, if you ask me, sir, I'm to talk about reservation is the bane of this country. A day is not far off when the country is heading for a civil war among the reservationists as well as the anti-reservationists. Because the question is, our children, especially people belong to the general community, are being deprived of their seats. You are saying brain drain and all, they are being sent to foreign and all. But when you cannot give them opportunity, why will they stay in India? So the question is, it has to be had a relook. You have Article 15.4 of the Constitution also. The great Ambedkar, who wrote the Constitution, said reservation is only till 2K, not beyond that. But we are in 2024. We have seen 3 decades almost. Well,
Sir, is oral partition is considered as a primary evidence, sir?
Sir, the question is oral partition. No doubt written partition itself, when you're practicing, it's very difficult to prove also. But oral partitions, you have got cogent evidence, substantial evidence, documentary, let us say, circumstantial facts, strong witnesses. You can definitely prove oral. Nowhere it is said the agreement should be in writing. But if it's writing, it is safe. But if it's oral, you'll have to. The standard of proof is much more than what is for a written document, sir.
Thank you so much, sir.
Yeah, welcome.
Thank you very much.
Sir, I am Ram Prasad. Sir, I am Ram Prasad.
Ram Prasad,
Chappan.
I have during the subsistence of agreement of sale.
Yes, go ahead.
Seller sold to another person.
Right.
That person mortgaged that
a party, not made a party.
Not made a party.
Right.
Deposit of title deed executed.
Right.
So now, could you explain?
Sir, if we have sold it during the subsistence of the earlier agreement, because the subsequent purchaser does not get any title for simple reason. He is not a bona fide purchaser for value without notice. But one thing you can do is the subsequent purchaser, you can implicate him as one of the defendants to say that it was done during the subsistence of the earlier agreement and that so-called agreement is not valid and cannot be enforced. So the question is, it's safer to make the subsequent purchaser also a party, and if there is any agreement in his favor, you can get that agreement. If the agreement is registered, take a certified copy and then get that agreement duly cancelled, sir, or declared as null and void.
Initial stage, during the pendency.
During the pendency of the suit, you're saying. During the pendency of the suit, there is one section 52 of the TPI list pendants, number 1. Number 2 is to say that the so-called agreement or so-called sale is not valid because the earlier sale deed is not cancelled or revoked. The question is, you can make that purchaser also a party to be on the safe side.
Okay, sir.
And you can take an injunction also asking that party not to alienate it, because if not, it will go on endlessly. This man will travel to C, C will transfer to D, D like E, and till Z also.
Yes.
You follow, sir?
Okay. Okay, sir. Okay. Thank you, sir.
Thank you, one and all. And we'll see you tomorrow again. The class is not yet over. Thank you. Thank you very much.
Thank you, sir.
Thank you.
Thank you, Kalyan, sir.
Thank you,
you,
Alesh
sir.
Kumar Garu. I request you, please go ahead. I'm waiting for your response. Sir.
Thank you, sir.
WhatsApp number పంపించుకుంటారండి.
WhatsApp number కి పంపించండి.
ఓకే సార్. తర్వాత సిపిసి నోట్స్ గురించి చెప్పారు, బుక్ గురించి.
నేను మీకు చెప్తాను సార్, మీకు అన్ని అందుతాయి. ఎవ్రీథింగ్ విల్ కమ్ టు యువర్ మెయిల్ బాక్స్. ఈవెన్ వీ హావ్ అ ప్లాన్ టు డూ ఇట్ ఆల్సో.
అమెజాన్ లో చూసాను సార్, అందులో అవైలబుల్ లేదా?
అందులో అవైలబిలిటీ లేదు. వీఆర్ రిక్వెస్టింగ్ ఈవెన్ ఎవ్రీబడి. అంటే సార్ పుస్తకం ఎంత సక్సెస్ అయిందంటే హాట్ కేక్ లో వెళ్ళిపోయి. దిస్ ఇస్ ద థర్డ్ ఎడిషన్ వీఆర్ కమింగ్ అప్. థర్డ్ ఎడిషన్ వస్తున్నది ఇప్పుడు. పీపుల్ ఆర్ ఆస్కింగ్ ఇట్. And we are coming with evidence. We are coming in CRPC, and we have a lot of work to do. We are there with you.
Okay, thank you.
Thank you. Thank you very much.